one of the projects I give in tax research, have been giving for the last couple of years, is something called quicking, involving workers that deliver products on behalf of a third party. And of course the issue is the worker, delivery person, an employee or an independent contractor. And whether, maybe you've seen it as well, but there's been over the last several years, of course, with the increase, with the downturn in business, with, of course, withholding tax, Medicare, et cetera, all the various withholding taxes that exist, it's often more beneficial for the employer to simply treat the individual as or call him a worker, as an independent contractor, and leave the paying of the taxes and such to the employee or to the worker. And the services, I tell my students, the services, they're not stupid, they're just slow, okay? And so they have had for years various programs to deal with what's called a misclassification of these workers. And now there's a recent voluntary disclosure program that has been announced in order to entice employers to come clean, if you will, on their employee status. What's the relevant law? Well, certainly we have Code Section 3121, which defines what an employee is an individual who, under common law rules applicable, they're used in determining the employer-employee relationship, and so if services are performed for another party, they could very well have a employer-employee relationship. The service also has published Revenue Ruling 8741, which has 20 factors that we're going to get into to determine whether an employee is or a worker is an employee or an independent contractor. And then you also have the IRS publication 1976, which is useful in determining status of an employee. You also have had since 1978 Section 530 of the Revenue Act, which is a relief provision for employers. As I tell the students, tax law doesn't just appear in the code or the regulations or even in revenue procedures and revenue rulings. You find them in different sections of the particular revenue legislation of a particular year, and they're never codified. You can only find them by going back to that particular legislation. This is one of them. Section 530 of the 1978 Revenue Act created a relief provision for misclassification. And then you have the service's ongoing program of worker classification settlement program to resolve on audit, if there is an audit issue, a misclassification. And then finally, a month or two ago, the voluntary classification settlement program, which I'm going to talk about this morning. Now, Section 3121D says you have an employee if the employee meets common law qualifications of being an employee, which typically means the right to control. I mean, if you boil it down, if an employer has a right to control the worker often is going to be classified as an employee. And some of the criteria include, as I said, first bullet, behavioral. Do you have a right to control the worker and how the worker does the job? Now, that doesn't mean that the employer actually has to control the worker. It simply means, do you have a right to control the worker? If you have the right, then that tends to indicate that individual is an employee. Do you have any written documents, agreements, etc., that cover that worker because that might further define whether you have an employee-employer relationship. There's no special formula. There's no magic, bright line test, if you will. You're talking about many factors that need to be examined. And just because you treat the employee or the worker as an independent contractor doesn't necessarily mean that the service is going to agree with you. Now, the factors, and we list them, some are more, the revenue procedure says that you should look at all these factors, but some of them are frankly more relevant than others. Obviously, some of the factors, the first one being instructions, which often is brought up. Does the employer require the worker to be trained to do the particular task? In which case, that probably means that person is an employee. How integrated is the worker with the employer's business? What about, again, hiring and firing and paying? And how long is that relationship, and what are the hours, and is it full-time or part-time, etc. Other factors are, again, written documents, payment of expenses. Is the worker employed reimbursed for expenses? Does the worker furnish tools or equipment, or does the employer furnish tools or equipment? 15 and 16 are probably the most often cited by the courts in determining employee status, and that is, does the employee or the worker have a significant investment in the venture? Do they own the truck? Do they own whatever enterprise that they are involved in? Are they making a profit, losing a profit? Is profit relevant at all to the workers' the work that the individual is doing? Certainly, having a separate business and having other sources of income for those services, make it more likely that you'll be independent versus an employee. But there's no bright line test. Right to terminate, okay? If they can fire you, that is less important, because usually even in an independent contractor situation you could be terminated.